Hi, I'm Reed Bloodworth, the managing partner of Bloodworth Law, with offices in Orlando and Winter Haven, Florida. At Bloodworth Law, we handle business litigation for clients all across Florida. Today, I'm going to talk about types of tortious interference claims recognized in Florida. There are two causes of actions regarding tortious interference. The first is tortious interference with a contractual relationship. And the second is tortious interference with an advantageous business relationship. The elements for these causes of action are very similar. If you want to succeed on a cause of action for tortious interference with a contractual relationship, you have to plead and prove the existence of a contract, the defendant's knowledge of the contract, the defendant's intentional procurement of that contract's breach, and damages to the plaintiff as a result of that breach. Similarly, to succeed on an action for tortious interference with an advantageous business relationship, you must plead and prove the existence of an advantageous business relationship under which the plaintiff has some legal rights, knowledge of that relationship by the defendant, the intentional and unjustified interference with the relationship by the defendant, and damage to the plaintiff as a result of the tortious interference by the defendant. These causes of action often overlap. You may plead both of them in one case. Sometimes we run into these in the context of an employee or an officer, someone higher up in a company, leaving to join a competitor. And a lot of times, you'll see these claims in conjunctions with lawsuits for non-competes. For example, tortious interference with a contractual relationship would be as follows. Company A and Company B are competitors. They don't like each other, and they would go out of their way to really harm the other one. So Company B goes to a high-ranking employee at Company A and says, hey, we really want you to come join our company. We know you have a contract and a non-compete, but we don't care. We'll pay you more money, and we really want to stick it to Company A. The employee leaves Company A and joins Company B. As a result, Company A is financially damaged. That is tortious interference with a contractual relationship. As part of the cause of action in trying to prove tortious interference with a contractual relationship, proof of some element of intentional harm has to exist because it's an intentional tort. So it can't just be about open competition. Intent is something you have to be able to plead and prove for a cause of action for intentional tortious interference with a contractual relationship or with tortious interference with an advantageous business relationship. Again, I'm Reed Bloodworth, the managing partner of Bloodworth Law. If you're dealing with a business dispute, give me a call. Let's discuss how Bloodworth Law can help you, your family, or your business.